Today's question, what is the 5-year look-back rule for Medicaid planning? If you've looked into doing Medicaid planning, you've perhaps seen in the literature references to the 5-year look-back rule. What this is talking about is any planning you do must be done 5 years ahead of the time when you need to apply for Medicaid assistance. So for instance, let's say you want to give some property, the family cabin, to your children now and get it out of your name, out of your estate. If you were to need to qualify for Medicaid within 5 years, that would be considered a divestment and counted against you. What I mean is, if you gave the cabin away today and 3 years from now you needed Medicaid assistance, Medicaid would look back 5 years and see that you gave away that family cabin, let's say it's worth $150,000, to your 2 children. They would then apply that $150,000 gift as a penalty and make you wait an applicable period, the penalty period calculated according to the amount of the gift and how long ago you gave it, until you could receive Medicaid assistance from the state. So when you hear about the 5-year look-back rule for asset transfers, it's dealing with 5 years before the date you'd submit your Medicaid application. If you're looking at doing Medicaid planning, I recommend you consult with a qualified estate planning and Medicaid planning attorney to go through all your options before you would consider and implement any of this type of planning. It's very fact-intensive, and it's best to involve the services of a knowledgeable lawyer to make sure you do it correctly and not do something you would later regret. Great question, and thanks for asking.